So what I've actually asked the judge at this hearing, whether she could enter a summary judgment, because the counsels or the defendants, they didn't submit a notice of, the counsels failed to actually lodge a statement of defence against my application. I can confirm and I can verify that during the whole process, since this case was pending in court up to December 2018, the defendants or the counsels on the behalf of the defendants did not submit a statement of defence against my claim. But in saying that, judge did make an order on her judgment, did note in her judgment that the counsels were to make a statement of defence against my case. However, that never happened. So to this day in the court, the counsels on behalf of the defendants, they have not submitted any defence. However, according to the district court rules and the laws, there is a procedure, and it actually still exists today. And this year is January 2022. Because I've had to use a system because of my case, I have noticed massive changes in regards to how you lodge civil cases. They've made a lot of changes. However, I can confirm and verify these laws and these protocols here, they still exist in the legislation. So even though this happened in 2016, but this is just confirmation. So what it actually means, I've actually won my case. The counsels and the defendants did not defend their case because they had no evidence. That's what a civil case is all about. But they didn't. They didn't submit a statement of defence. So because they didn't do that, according to the laws in the court protocol, an order means a judge is now allowed to make an order of judgment against the defendants. I will now continue on the same document, but I will just going down. So I just wanted to go over the right to interplead. Now this here was also on this document. This was more like a real urgency, like you're pleading with the court to make an order because my liberty was at stake. And there were so many other things behind the scene that was going on as far as my liberty was concerned, and just, trying to go forward. In desperation, for those that don't know, when you use this law, right to interplead, you're basically pleading with the court to make an order, or you want to have this matter be treated like in a matter of urgency. Like you're actually begging the court, or that's what it's called. You're pleading with the court to see the high risk and all the other issues surrounding my case, that it's actually a high risk or a high priority case. So this is what the right to interplea, because I now fall in that category. I already knew from the beginning how urgent my case was, but I was in a trap environment or a trap set of circumstance. By circumstance at this point of time, I was begging the court to make an order because I wanted this case to be closed so I could find a job, so I could seek to protect myself or defend myself, because I wanted to find another job and move forward, going forward. But I was definitely in a trap set of circumstance out of my control. So I'll just read this. This is on the same application. As you can see, I scrolled it down. Right to interplead. The plaintiff has the right to interplead Rule 4.58. 1. When a person A is under liability for a debt or other cause of action, money or chattels for or in respect of which A is or expects to be sued by 2 or more persons making adverse claims, or may apply to the court in accordance with rules 4.59 to 4.64 for relief by way of interpleader under Section 1 of the Act. 2. If a person B who is not a person against whom an enforcement process under Part 19 is issued claims money or chattels taken or intended to be taken by an officer given effect to that process or the process or value of these chattels, the officer may apply to the court serving notice on the execution creditor, the execution debtor, and B in accordance with rules 4.59 to 4.64 for relief under Rule 4.63. Number 3, please refer to the interlocutory application right to interplea dated Thursday 9th of February 2017. Now, this document too was actually a sworn document before a registrar. This here, basically, I'm asking the courts for an urgent resolution or to treat my case like as a matter of high priority because it was that serious. I just knew how serious my predicament was. Attached with this, along with the other exhibits that was attached to this, was I attached the District Court Rules Act 1947, and then it's got the 111 interpleader. This here automatically, the courts have to treat, normally, a competent judge or a registrar would normally see that as like an SOS sort of thing, really serious, and normally they would automatically treat the case as serious. However, my case was sabotage, but at this time my case was pending in the courts. All these laws were active during this case, even though that this is back in 2017, this hearing was, and when this application was submitted before a judge, it still applies before and after the facts because they existed. And I'm just going through some evidence just to prove that what I said is what I did. The case goes back on to the first case management conference that I had. I won't bother reading about that. I was just letting the judge know that I felt that the hearing was an unfair hearing at this conference and that I thought counsels have misled the court. And the Ministry of Justice, Civil Deputy Registrars and Management have not followed through my request as the plaintiff to have letters on file to be brought to the judge's attention before the first case management conference. This is confirmed by emails, correspondence submitted and mentioned above. In this civil litigation, there is clear sufficient evidence and facts to justify a right to sue without a doubt. The evidence speaks volumes of unfair, unjustified and unlawful breach of contract by the defendants. So here I've put in the transcript. I've actually asked matters leading up to this hearing. I've actually asked in this application, I'll read it, 3 matters leading up to the hearing, 1815, order for transcript of evidence. So what I've actually asked, I've asked the judge, I wanted the plaintiff would like the recording of the meetings for evidence for trial to be released. You can ask for that. Your court hearing evidence or anything that the other party has that you need, you can make that kind of request to the judge. So I'm asking the judge here, I'll just read it. 1. On Thursday 19th of January 2017, the plaintiff made an application for order for transcript of evidence under Rule 18.15. The plaintiff would like to make an application for the recording of the first case management conference dated on the 1st of November 2016 at Auckland District Court before Judge M.E. Sharp to be released for trial purposes. Number 2, the plaintiff would also like the recording of the meeting with Dr. John Joseph, psychiatric, dated on Thursday, 4th of February 2016 at 3337 Paramount Drive, Lincoln Road, Henderson, to be released for evidence if this case should reach the jury trials or judge alone trial process. So what I've asked the courts in this application, I wanted the recording of our meeting because I asked for the recording and Dr. John Joseph gave me a transcript. But it wasn't consistent with the recording that I'd recorded. So I've asked for this recording. The recording of the District Court hearing on the 9th of February 2016, heard at Waitara Unit before Judge A. McHardy family, that's just the name of the court file. So I've asked for on this application, I've actually asked the judge too for the transcript of the hearing that taken place whilst they used the Mental Health Act. So that's the hearing I'm asking for. The last one is on the number 10, which was transfer with or without application, Rule 20.56. May it please the court that the plaintiff would like to make an application to have the civil case transferred to criminal jurisdiction should the parties not resolve the matters before the court on the 27th of February 2017. So in this application, I'm actually asking the judge anyway that I'd like my application to be transferred to the criminal courts. Because I can tell you just from the beginning, the case itself really was a criminal case. So we've come to the end of this interlocutory application. So yeah, just so you can see that it was signed by a registrar, then it was sent to the councils, and just to confirm and verify during the process of this whole case, this whole civil case, the councils were served personally with all the exhibits. I did everything myself personally, so I can actually confirm and do affidavits to confirm everything that I said I did myself. So they can't say they didn't get it. But this is the importance, I guess, common sense, why it's so important that you do things yourself. I find it you're the best witness, really, to be honest. Or if you get someone else to do it, you just got to make sure that you cover, because you can get other people to serve your documents. So as far as my whole case is concerned, I've litigated this case myself and I've followed through all the court protocol and procedure, but my case has definitely been sabotaged. So that is the end of this document, and hopefully you found that helpful, and I'll see you in my next clip. Hi, today is Friday, 25th of May 2018. The file is officially now with the Court of Appeal, and so I'm just waiting now to hear what is the judge's decision. So what I have found with what I've been going through, the greatest disadvantage is when your privacy's gone and being subject to a project without your consent like I have, you automatically are disadvantaged because people have basically invaded your privacy to study you, dig out your past, and doing unlawful investigation without your consent. So when that is actually happening to somebody, it is automatically a criminal case because I haven't consented to it. In fact, anything that you don't consent to legally, it is criminal. This case has been now pending well over 22 months, unlawfully, as already mentioned in my other little video clips. As time has gone on, the micromanaging of my circumstances and my environment has been really quite unsafe, you know, in the fact that when you go out, you know that you've been criminally, your environment is contaminated, and you're subject to something that's not right. But regardless, you know, of the circumstances, the only way really to get yourself out of it and to sort out any issues is the court system. So I've been doing this case now for well over 22 months, and the experience I've found, although it's the hardest thing is the emotional side, but when you pass all that, bar that, the emotional side of things, the experience has actually been quite rewarding in so many ways. And also just the reality of how appalling the system is for the public, because now I'm on the other side as any member of the public to deal with my medical records in court. Now, what I've found also is when they're micromanaging your circumstances, they're basically controlling everything. So they know in advance where you're going, and so they're able to give wherever you're going, instructions what to say to you, you know, so they can make things really difficult for you. They've been given instructions to tell you what to say to you, and that's the end of that, and just make it really difficult and stressful, which is what has happened to me. The other thing is I found with the last time I tried to lodge my documents over the counter, they had issues even date stamping the originals. Now, it's the usual process is that every single originals, the councils are supposed to get originals, the judge is supposed to get original for the court file, and myself. All the parties are supposed to get originals, and they should be date stamped. Well, now they've changed it, and I know it's not because they've changed it, it's because I'm being deliberately discriminated against, which is a real concern, because it shouldn't be happening, because according to the law that's still a criminal, you know, for government employees and staff to you know, deny the public their right to justice, regardless what it is. But so yeah, there were issues there now that they're trying to tell me that they'd no longer date stamp originals for the councils or the other parties. The only originals that they now date stamp is for the judge's file, for the court file that they receive over the counter, which is not good, because I have found that I've had people actually tampered with my documentations. Bearing in mind my privacy's gone, so I've had problems with just people entering into my premises when I'm not there, you know, hacking into laptops. Yeah, so all that has happened, and so so that was another not good issue that I had to deal with when I went to lodge my file at the Waitakere District Courts. But somebody is giving them instructions that they're not to do this, not to do that, when I know you can, but yeah, it's more of a personal vendetta, and it's not good. But regardless of all that, the file is officially now with the judge, the Court of Appeal judge, and the councils are all aware. They don't transfer court files now from court to court. Today is Monday, the 27th of August, 2018, and I'm about to ring the case officer or case deputy registrar who's managing my case, Crichton versus City Med and Ministry of Health at the Court of Appeal. So I'm just ringing Court of Appeal and asking for Chris Abraham.
Appeal speaking.
Hi, Chris. It's Minna Crichton here.
Hello, how are you?
I'm good, thank you. Have you got a moment?
Yes, I sure do.
Okay. I've just been going through my application, and I was just reading Judge Clifford's judgment.
Yep.
I'm kind of just going through what he wrote.
Yeah.
My concern is that his judgment doesn't indicate that he's actually read the interlocutory application. Because there was an interlocutory application submitted on the 16th of May. But there is no indication that he's actually read anything I've submitted. There's usually a judge will refer to what he's disputing or what I'm, me being the appellant, the applicant. My discernment of what the judge has actually written, he doesn't indicate he's even read the interlocutory application, which is what he should have been reading, because that's a sworn affidavit. That's a sworn document, it's a legal document. And because he does state in his decision that a interlocutory application should have been submitted. So he's indicating that he hasn't cited one from the way I'm reading it. But that is the reason why I submitted an interlocutory application. That is what he's supposed to be actually going by to, because it's a sworn application. So I just thought I'd just bring that to your attention, because the way I'm reading the judge's judgment, it doesn't give me any. It's like the other judges who've made unlawful strikes. They haven't read the file. Like that's a massive concern, because they haven't read the file. You know what I'm saying? Because the councils haven't, from day one, when I submitted my notice of proceeding and paid for it and all the rest of it, the councils haven't submitted any evidence at all. None. Because there's no case to answer. So what I'm concerned is, me being the appellant, and they've gone ahead and made judgments kind of like indicating that I've got a mental health when there's no evidence from them. And yet they haven't cited, or they haven't even considered, because and the judgment speaks for itself, that it clearly indicates that they haven't referred to any of the exhibits that were submitted in the courts or anything like that. And that's a big concern. So what I'm saying is, what Judge Clifford has done exactly the same thing as all the other judges have done. And all they're doing is just going blind and just following whatever the other judges are saying, but they haven't even considered the evidence that I've submitted. Like, there's no indication that they've even read it. There's not even the interlocutory application, which is the most, out of all the documents that I've submitted, even though all the appeals were all there, all 3 appeals were in there, and I met the deadline that set out the 20 working days. I've met them twice. But my concern is that, reading the judges, because I'm used to reading judges, judgments, because, I've dealt with all this kind of thing, and the judges usually indicate or refer to the exhibits if they've cited them. So my concern is that none of the judgments that any of the judges have written indicates to any of the exhibits that's been submitted, or any of the evidence that I've submitted at all, being the appellant. So they weren't even viewed, and the judgment speaks for itself. So what I'm concerned is that they're just writing all this repeating mumbo jumbo, like the other judges. Then they write, then they refer to the law, and then they refer to cases to support the law. The problem that I have, there is no evidence to support what they're saying, what they're writing. And, in the court of law, no one can make a judgment on anyone unless there's sufficient evidence.
Okay, so the judgment of Justice Clifford, the only thing he was considering was whether or not he was reviewing essentially my decision not to accept your document for filing. So that's kind of the only thing he took into consideration. So the interlocutor application, it was kind of to the side of the matter that he was actually considering.
But he talks in his judgment that interlocutory application should have been submitted. It says there in his statement, like he actually talked about it in one of the laws he was referring to. What I'm trying to say is I did submit one, but none of it was referred to it. Like his judgment indicates he hasn't read my interlocutory application that would have been a real strong application to support my whole application.
Which application are you referring to? Is that the one transferring the proceedings?
No, I'm talking about the interlocutory application on notice for a review of the Deputy Registrar's decision, and that is under Rule 7(2).
So you mean the application to review my decision not to accept your document for filing?
Yeah, and yeah.
That's what this judgment is about.
Yeah, but it indicates the judge hasn't read it, though.
Well, he must have read it if he made a decision.
He doesn't indicate.
No, but he wouldn't have just reviewed my decision off his own motion. He would have read the document asking for a review of my decision.
Yeah, well.
So he must have read it.
There's no indication that he's read anything in regards to my whole file.
Well, I mean, he's issued a 9-page judgment which disagrees with that, but... So, I mean, okay, well, what...
The biggest concern is that in saying that, he still made a judgment without any evidence. Well, without any evidence to indicate that I have to support. What I'm saying is they're doing unlawful strikes.
No, well, but all he said is that the document that you filed could be accepted for filing. There's no mention on the merits or anything, and he set out how you need to proceed, which if I remember correctly, we discussed this last week.
I know, but what I'm trying to say is that I'm just going down a long, massive path that's really not only abuse of the court system, but also a waste of my time. But what I'm trying to say is that the interlocutory application actually indicates all the application, basically the whole file, like a roadmap, and you said to me in the last conversation we had that I needed to submit Judge Gordon's decision, the appeal on the 20, that was made on the 26th of September 2017.
Yes, that's what you need to file in.
I've done that.
Application for leave to appeal and extension of time.
Yeah, they were all in there though. That's what I'm saying. Everything you told me to do, they were already in there. It was on the cover sheet. Every single judgment, but then the interlocutory application is actually set out in a format like a roadmap, because I know that it's when a new judge, like I know in the old system, a judge will handle a file from day one to the end of the court case until it's closed, and the only time they withdraw if there's a conflict of interest or something comes up, that then they withdraw. They do that so then there's no confusion, and because it is like confusion, it's quite a lot of thing to take in a case. So what I'm saying, because I know that each judge is different, I've had like 4 or 5 judges in this case, but in that interlocutory application, I kind of set it out like a roadmap, and then the applications that I sent with this interlocutory applications refer to the appeals, refers to the judge's judgments, and refers to the laws and also the exhibits